And on the international side, it's very important to be mindful of what's happening beyond Canada. The framework that I've provided has been criticized as being woefully inadequate to handle privacy as we need it to in the modern era. And so Canada presently is considering changing its entire privacy law framework. And it's doing so following the trend of what has happened in Europe with something called the GDPR, General Data Protection Regulation, which is arguably the most strict privacy law in the world. And most recently in the US, we've got something called the Ccpa. Ccpa is persuasive across the US, and if it isn't already, it soon will be. And I'll give you an example. Microsoft had declared that if it's going to follow the Ccpa in California, it may as well follow the Ccpa in every other state to simplify its operations so that it didn't have different operations in different parts of the US. That would be a logistical nightmare to deal with. So if Microsoft is doing that, it's likely that other big data companies in the US will follow. And so what I foresee happening is that the Ccpa will set a US standard. And then following this trend, most recently in Canada, we have provincial legislation out of Quebec called Bill 64, which again increases the ante, or increases the standard rather, of privacy law, but only with respect to Quebec. As far as the federal reform of privacy law is concerned, I expect that this new Bill 64 out of Quebec will be very persuasive with respect to what the standard will be federally. Because again, we're dealing with a global trend of privacy law and privacy accountability increasing across the board, from Europe to California, across the US, and now in Canada, starting with Quebec. And the next major chapter in this story of global regulation of privacy just took place recently, last month in mid-July. Between the US and EU, there was something called the Privacy Shield, which governed how data was transferred between these two jurisdictions. And it was determined in the EU that the Privacy Shield was contrary to EU privacy law, so it was contrary to the GDPR. And the reason is because the GDPR focuses on individual rights. Meanwhile, in the US, there's a great emphasis on national security. So you can see that there's a conceptual clash between national security, what's good for the state and what's good for surveillance purposes, and on the other hand, individual rights. You know, what's good for me? How do I protect my privacy? How do I make sure the state does not intrude on my communications? So that method of data transfer between the EU and US was invalidated last month. And now big companies are scrambling, trying to figure out, what does this mean for our data transfer operations? From my understanding, there is another version of the Privacy Shield in the works, but we don't have any particulars on that. And at present, there are other bases of ensuring compliance with international data transfer laws, but they're much harder to meet. So I would expect an update on how US-EU data transfer mechanism will happen shortly, at least within the next month or so. Now, why is that important to Canada? I will tell you. Often in Canada, what happens is Canadian business will outsource its data processing obligations or its data processing necessary tasks. If it outsources those tasks to Europe via a US company, we have to examine how is that data going to be treated now. And also, the Canadian privacy law framework has been recognized for a while that it's inadequate. But at present, the privacy legislation in the private sector in Canada was declared adequate in Europe. That was before the GDPR came into force and raised the privacy law standard across the board. The Canadian privacy law framework is now being reconsidered, and it will be reconsidered this year. So long story short, the Privacy Shield invalidation occurred because of US surveillance practices. Meanwhile, in Canada, we just had a new cybersecurity surveillance framework that was installed a couple of years ago. So there's a real fear that Canadian privacy law will no longer be adequate under EU law. And if that happens, then the method for transferring data between EU and Canada will also be at risk. And I suspect we'll hear more about that sometime within the next 3 months. So big things are happening on the international stage. I didn't include it on this slide, unfortunately, although it is in my book. There are upcoming international treaties as well that deal with data handling and data transfer, and that will complicate the field even more, which is good news for me because you'll need a lawyer to help plan things out. Not so good news for you because it will complicate your operations. So people like myself, we should be kept on the ready on your roster in order to ensure that your operations have minimal downtime going forward as these new changes come into effect.